Occasionally, law enforcement gets directly involved in Child Protective Services investigations. This can be a shocking and confusing experience for families, especially when the allegations seem frivolous. There has been a decades-long argument over whether CPS are law enforcement or social service providers, and thus far, they remain classified as social service providers. While this means they don't have the same authority or privileges as law enforcement, they aren't bound by the same rules either. Most commonly, if a CPS investigator feels their safety is at risk due to the allegations, they may request law enforcement to accompany them, often known as a co-assist. In these cases, law enforcement is typically there in a supportive role, ensuring the safety of the CPS investigator. This presence is almost universal if a firearm is known by CPS to be kept in the home. Since CPS, as social service providers, cannot remove your children on their own without your consent due to the lack of legal authority that law enforcement has, they utilize the authority of law enforcement by proxy to do so. This is true whether CPS obtains a court order before or after the removal is conducted. They do so by making a statement to law enforcement about their belief of immediate or impending danger of serious harm to the children. This provides law enforcement the authority to act under what are known as exigent circumstances to facilitate the involuntary removal. It's important to note that law enforcement is not typically present during a removal in which you sign a voluntary placement agreement or a similar arrangement. Although it may not feel voluntary if CPS intends to get a court order for involuntary removal if you refuse, it is voluntary on paper. And in CPS cases, that's what matters. These types of agreements have become more common over the years, have no legal oversight, and have come to be known as hidden foster care. Child advocacy centers are regional multidisciplinary centers where law enforcement, CPS, and other professionals collaborate on interviews and assessments. While this reduces the number of times a family has to be interviewed, if your family's presence is requested at a child advocacy center and you haven't lawyered up already, this is when you do it. A trip to a child advocacy center is a sure sign that both law enforcement and CPS are highly likely to conduct an involuntary removal soon with a dependency case in the family or juvenile court and a simultaneous criminal prosecution in the criminal court. If law enforcement shows up at your home with CPS, ask why they're present or what their role is. If there is no court order and it isn't a non-consensual removal, you can ask them to leave, but make sure you assess the likelihood of CPS returning with a court order where you lose all discretion you do have. Always ask follow-up questions as needed to understand the situation better. While the presence of law enforcement can be frightening, it's crucial to determine the reason for their presence in order to accurately assess your risk and strategically respond in real time. Remember that every case is different and requires a response tailored to the circumstances, allegations, resources, and local law and policy. Don't face it alone. Get an insider by your side to reduce your chances of a nightmare like this. If it occurs, you'll have an expert partner every step of the way. Visit cpsprotect.com or call toll-free at 844-633-KIDS to find out more. CPS Protect Consulting Services, saving children, preserving families.